Yeah, we are going to have a look about the deed of will. A living person can transfer his property to the another living person under Transfer of Property Act as a sale or some other else. The sale is a general. In a sale, the consideration is a major role. The consideration means something to be written. If I'm buying the property, I have to give some money. That should be a equivalent. That is called a consideration. If anybody wants to transfer his self-owned property after his death, the will is only the option. Here we are going to look about the two kinds of will. That is the privileged will and unprivileged will. The privileged will means the Indian Succession Act and the government has given some privileged exemptions and relaxation to the person who is working in a endangered zone, like a military or some other endangered workers and who's serving for a country. They have some privileges to writing a will. They can even made a will by oral with a single witness. The privilege has been given to them because of the death may happens to them at any time. And the another one is the unprivileged will. Unprivileged will substance the important judgment as given by the Honorable Supreme Court under AIR 2020, that is very recent judgment, Kavitha Kumar versus the Parimal Metha. In this case, the Honorable Supreme Court judges detailedly discussed about the will. Majorly, they are discussing in a Indian Succession Act section 61, 268 and 89, along with the Order 8 Rule 10 of CPC and the Order 14 Rule 2 and Order 15 Rule 6 of Civil Procedure Code to the applicability of the probation. In this case, the Honorable Supreme Court judges detailedly mentioned what the contents the will should have, what it should not. The transferor mentioned the property which he has not belongs to him. It also mentioned in that the witnesses also examined the controversy and he has not mentioned all the legal odds. So the detailed descriptions has been given by the Honorable Supreme Court. All the legal odds should be mentioned in the will. While writing the will, all the legal odds should be mentioned. Either it's be transferred to them or not, but everybody should be mentioned into that under role of them. The person who is getting a benefit and who has not getting benefit also mentioned. The qualification and disqualification also mentioned. In this case, there are many suspicious circumstances has been happened. Even the witnesses also controversy. So the case was been dismissed by the Honorable Court to probate. Before that, we should know what is the probation and the letter of administration. The probation means while writing the will itself, they are mentioning the executor. The executor who is going to perform and probating the will is called the executor. And if not mentioned, the letter of administration may be appointed. Honorable Supreme Court particularly mentioned Order 8 Rule 10 about the written statement. Generally, if the written statement has not filed, the decision will be taken by the judges. But they particularly mentioned even if not filed, the judges should testimony the genuinity of the will and witnesses and evidences. Here I am conclude with my opinion, that is the will getting very much time to probate. The Indian Succession Act is a very older one. It was made by the British, and in the part of will, there are many amendments we need to execute very easily, because nobody is going with a will because they are getting afraid whether it will be probate or not by the Honorable Court. So kind of specific performance suit, declaration suit, it should be go with like a easy manner, is not very much easy in a court. So the public getting hardship, this is to be amended by the easy manner to performing the will. Thank you.